If you don't read the newspaper, you're uninformed. If you do read it, you're misinformed. What is the long-term effect of too much information?
Information, I just need some information. I've been dying. Is it lack of education? I've been reading without any transformation. I'm addicted. Is it overstimulation? Hey.
Welcome to the Sixth Sense Report.
Hear ye, come one, come all. You are listening to the Sixth Sense Report with Joel Nikoloff and Darnell Samuels.
This one seems like a bit of I almost want to say somber topic, because the consequences of some people's decisions could be substantial. And, livelihood is not a simple thing. So, yeah, no, I'm sort of sitting on the, in anticipation of this conversation, thinking like there may be some listeners where this is a very relevant and stressful topic.
Mm-hmm. No doubt, man. It's all about the job or jab. That's if that's how people are calling it these days, right? Mm-hmm. This is what people are debating about, and it hits home for a lot of people, because a lot of us know people who have opted out not to get vaccinated, and as a result have lost their job. And so, we're like, okay, let's talk about it. Let's bring on somebody who is actually at the front lines of dealing with these issues. So, ladies and gentlemen, please welcome constitutional lawyer John Sikkema.
Hey guys, good to be with you.
And thank you.
Thanks for coming on, man. I wanted to first say that the way this show came about was man, it's amazing what happens in WhatsApp chats. And, and people add you to these random WhatsApp chats. So I got I'm in a WhatsApp chat with some people who are not fans of the vaccine mandate. And and then someone dropped a link to you, John. I think it was Tyler. Tyler, good friend of the show. He dropped a link on, I think, a talk you were doing or something, and I was like, "Ooh, this is timely and necessary." And so I was just looking you up, and I was like, "Oh, this guy would be really cool to." Because I would have questions, and because I wasn't able to make the talk, but I was like, "Oh man, I'd really like to ask him a couple questions." So that's how this kind of came about.
It's good of Tyler, good guy.
Yes,
yeah,
yes, we like him a lot.
Tyler's a legend around these parts.
So John, you your title or terminology of constitutional lawyer, reminds me briefly when we talked both Andre Schuten's presentation at the Ezra that we both were blessed by, both that, and when he was on our show, he sort of made the reference to the fact that constitutional sort of perspectives, issues, understanding was all further developed post-education for him. And so I was wondering if you could give us a bit of a background. How do you come to be a constitutional lawyer? Do you have sort of a similar background in that your interest in the Constitution kind of came post the education frame because there was a limited amount during that time frame, or did you have a different experience than what Andre was saying?
Yeah, I think typically legal theory and legal and political history is not terribly important in law school today. It was decades ago they kind of adopted the case method, where they throw you a pile of cases to read. You kind of learn how judges make decisions because you're reading their reasons. And of course, we cite precedents. In a common law system, you're relying on cases. So of course, it does make sense to read cases. But in terms of more foundations courses to kind of maybe see how the law fits together and some of its key ideas and its history, development of parliamentary democracy and the rule of law and so on, that tends to be less important in law school. You kind of have to seek out those courses. So, but I would say I had an interest in before law school. I was a political science student. I did take a constitutional law course as well as political theory courses, and you can kind of see how certain key ideas you take in history and political theory courses show up in even in a constitutional law class, right? Even if they're not being the history of it isn't being discussed directly. So yeah, I mean, it was an interest for me before going into law school, and then in law school, kind of sought out some constitutional courses and other courses that kind of lend themselves to political science kind of person, like the relationship between legislatures and courts and what their roles are supposed to be.
Would you say that that it's a calling, being a lawyer?
Oh, sure, certainly, yeah. I think that all professions we're trying to work out our calling, and we may be called to do something at different stages of our lives. So I hope, I think this is a lifelong calling. I hope I don't lose my license for ideological or other reasons. I'd rather lose it for ideological reasons, not going along with ideological requirements than for lack of genuine professionalism or something like that. But no, I felt a calling to it, a passion about it, and the issues, especially particularly religious freedom for me in quite a secular age where I feel like that's often not well understood and not fairly characterized what religious freedom claimants are really seeking and what they're about.
Mm-hmm.
But yeah, for me, it is a calling.
Mm-hmm. You mentioned that the method in which you guys are being trained, you said like before it was like historical law, and now they offer you cases to work through. Which one is one better than another? What's the benefit between the two?
Yeah, I think the easy answer is you need both, right? In any law course, even though you're reading cases, it's going to be structured in terms of picking key cases, and a good prof is going to try to tie them together for you. But I think there were previous attempts at kind of systematizing law and kind of painting. I mean, this was really done. The common law system develops to deal with problems kind of piecemeal, and then referring to other cases that deal with similar issues. And in a way, that's good that we don't at the outset say, here's kind of a system of statutes that we're going to regulate all of society in a kind of a rationalist way and expect it to work in every case. Life is a bit more complex and organic than that. So the common law system in that way makes sense. And yet my understanding is, of course, I went to law school fairly recently, but my understanding is there was a bit more of an emphasis on the system and the principles that came to be core to the common law across different areas of law.
Mm-hmm. So how does your constitutional interest finishing law school result in being a founding member of the Acacia group? Yeah. So how do you end up, I'm assuming, like, did you do articling before that and then become a founding member? Yeah. Maybe you can give us some context on your, career path, let's say, to where you are today.
Sure. Yeah. I went into law school not knowing where I'd end up, but I did the thing that people typically do to pay off law school, tried to find a job. In my case, I managed to find a Toronto job at a kind of a mid-sized firm. Thankfully, one that was focused kind of on public law. We did some education law, some human rights law. By public law, I mean anything that's kind of interacting with a government body, a regulatory body, or that's public law. Anything related to government. And then after that, I was doing I had done during law school some work for a couple of Christian think tanks. After articling, I was hired by Christian Legal Fellowship and got to work on certain important cases there. The Carter case, which is an assisted suicide case. The Trinity Western case was a major religious freedom case about whether a Christian university could open a law school while it had a religiously based code of conduct for students. And after just a year there, I was in conversations with another Christian advocacy organization that asked me to move to Ottawa and work for them. So some similar work there, but also some public policy advocacy and meeting with MPs and that kind of thing here in Ottawa. And that was ARPA Canada, the Association for Reformed Political Action, where you mentioned our friend Andre Schutten, where he continues to work. And a friend of ARPA's is Alberto Polyzagopoulos. He's been doing constitutional law as a private sector law firm, regular litigation practice. He's been doing that for, I believe, over a decade now. So Andre and I were doing some constitutional cases, but within a Christian advocacy organization. And typically, you're not the one involved in the lawsuit, right? So a lawyer like Alberto was practicing law, taking any client that would come to him. Andre and I were, targeting cases where we could be an intervener And in one case, we did sue the Ontario government. ARPA did and won, and they had to pay our costs and everything. It was wonderful. But besides that, it was a different kind of practice. So Alberto wanted to start his own firm. He was a Christian in a kind of a mid-sized secular firm. He wanted to start his own firm, and he talked to me about joining him. And obviously, constitutional and human rights stuff would be a specialty in his vision of this firm, and also charity stuff that really serves the needs of a Christian community, Christian schools, Christian universities, churches. We do other stuff, but that's definitely a specialty for us. Yeah, and so I ended up joining him just a year ago.
Oh, okay.
Yeah.
Okay, nice.
So a new but exciting endeavor, I assume.
Yes.
Yeah.
A bit more opportunity to work on a variety of cases, but also in line with some of the stuff I was working on at ARPA. So we're kind of still on the same team, for the same causes. But finding different places to contribute. Yeah, slightly different roles.
Yeah. Now, the session that popped up in the WhatsApp chat, it was about a legal information session at Westminster Chapel. It was on October 24th, and so it was concerning, of course, job security, people's jobs being put in jeopardy because of the vaccine mandates. Can you fill us in on how that talk went, or even just some of the talking points that you're running into in light of this issue?
Yeah. Well, I suppose I better leave it to people in the crowd to say how it went. From my perspective, I thought the questions were really very interesting questions. In some cases, almost heartbreaking questions. These people obviously very sincere and not being in a context where there's any good reason for them to lose their jobs, but this is the situation they find themselves in. And they're often mischaracterized as people who are careless or thoughtless or whatever.
Rebel rousers.
Anyhow, so that session, I wanted to give people a bit of the basic legal framework. I think people aren't always given the best information necessarily, depending on what you find on the internet. There's certainly good information out there, but and so to kind of give a basic picture of the way the law works on this. So if you're in a labor union, things work differently than if you're not represented by a labor union, right? And if you're a regular employee, there's also the question. So there's kind of two questions. There's that regular employee versus unionized employee, and then there's government employee versus non-government employee. These are very important categories to kind of start with. And so if you are not a government employee, and if you work for someone who the government has not demanded they require you to get vaccinated, then your talk of charter rights, constitutional rights and freedoms is unfortunately in this sense not relevant, right? You can't claim a constitutional right against a private sector employer, and that employer also can only make a constitutional argument for you, or you can only make a constitutional argument on behalf of yourself in relation to the government if it's the government requiring you to get vaccinated, right? And then the other thing, like I mentioned about being in a union or not, if you're not in a union, you could potentially be fired for not being vaccinated. But the question is going to be whether that was being fired for cause or not, right? If you're habitually unsafe at work, you can be fired for cause and you're entitled to nothing. But firing someone for a cause is difficult in employment law. They have to be pretty serious misconduct or continuing misconduct. And
like not wearing your mask.
I think that it depends on the context, right? In certain contexts, not wearing a mask, if you're a PSW at a nursing home and you're not wearing a mask, that could, I believe a court would find that that's conduct meriting dismissal from your job with no severance, right? And I doubt that if you're part of a union, as many PSWs are, that your union's going to go to bat for you to protect your job if you're refusing to wear a mask while caring for people in a nursing home, like where obviously the most vulnerable population is. So so it's going to be context specific. So there's kind of this can you be legitimately fired, reasonably fired for cause question? And then there's also the another kind of set of legal questions around this is the human rights questions. And obviously, human rights can be a very broad term, but in this specific legal context, it means, are you being discriminated against or not accommodated based on your medical needs or your religious beliefs, right? So, if you have an employee who needs to step aside, step into a certain room a few times a day to pray. We think of Muslims, of course, as they might have a routine. I need to take a break to pray. As you as an employer, you can very likely accommodate that, and to not accommodate that is considered in our law discrimination based on religion, right?
Yeah.
Even if you're saying I treat all employees the same, no one takes prayer breaks or smoke breaks or whatever. Our law is such that they say that doesn't matter. You accommodate to the point of undue hardship. If it's not messing with your workplace and what you need to get done or costing you too much, you gotta do that, right? So in this case, when it comes to vaccines, there's been a lot of pushback from employers, government employers and otherwise, on the idea that you can have a religious objection to the COVID vaccine when people aren't when religious objections to vaccines per se are quite rare, right? So that's been a real struggle, and there's not really there's not case law on this yet. So there's some arbitration decisions in the labor context where arbitrators have found that mask rules and rapid testing are valid. Employers can require that. And I've also seen decisions where they say, a kind of vaccine or nothing policy goes too far in kind of a regular like industrial workplace context. That case wasn't in a nursing home. So the question of, in what context can you be fired for cause, in the context of when is an alleged religious position against getting vaccinated actually religious? Is it going to be considered to be protected under equality of religion? These are the big issues at play right now, on the legal scene.
With regards to an employee, I'm thinking about the scenario where you described the mask wearing scenario, and they want to give a pushback. Let's say they need an accommodation for medical reasons,
right?
The outside of what we're not talking about is those scenarios, right? Like the example you gave of someone getting fired. I was thinking about it in the sense of what would transpire for the employee, and I think this is good for the listener if they're experiencing this, or if they're thinking about it for other people that they know. It would be something along the lines of, oh, there's company policies. This person is continually reprimanded. And then that's what the courts would use as justification that this was termination with cause. Is that a fair sort of point to bring up? Or would it just, or the way you're describing it, the way you've seen it recently is, we deemed this policy appropriate and they're choosing not to?
Yeah. So in terms of dismissal for cause, it goes to a single instance could be severe enough, and I'm not talking about masks, but a single instance of misconduct in the workplace could be severe enough to merit firing you. If it's something like you work on a construction site and you weren't wearing the mask, well, one instance, two instances of not wearing the mask or not wearing it properly, having it down over your mouth. I mean, I would want to defend that employee if they were dismissed. But again, if they have a record, and this is why employers do this, right? You make memos to an employee's file, or you have a meeting with them, or you send them a warning or whatever that they need to get in line with the policy. That's something that an employer is going to use to back up their decision to fire someone if they can show that the person was reminded to get in line with the policy, right?
Mm-hmm.
Now a lot of these policies about getting vaccinated, they're new. They weren't there, of course, when someone was hired. So what we're seeing is for new jobs, and this is true across the public service, the federal public service certainly, that new hires have to be vaccinated, right? So it's kind of like you're agreeing up front. To get this job, I'm going to be vaccinated. But if you've been working there for 20 years, having a COVID vaccine or any vaccine probably wasn't a condition of your employment. So it's a new condition imposed on you, and employers normally have to justify that by showing a compelling safety need for it, and that it's reasonably balanced with your own the employee's own interests, right?
Now, would you as a lawyer make the case? So for context, I think it's if your salary, for example, was decreased by more than 10%, that would be deemed a constructive dismissal. So in what that idea, the reason I use the 10% salary as the example is when your job has substantially changed enough from what it was, whether that be by pay or function, the courts can rule that they've basically fired you and rehired you. That's
right.
That's what constructive dismissal means. So
that's right.
Would a scenario that you're describing where they've imposed the vaccine mandate, would constructive dismissals be a means of defense? And if not, what would the means of defense be when you're saying, well, you're imposing this new rule on me? I know you talked about reasonable accommodations and the person, so where are they going to look at the facts, let's say, to make those assessments? Yeah,
I mean, a constructive dismissal claim is kind of a way of going on offense. I suppose the threat of a constructive dismissal claim is a defense. So yeah, if you say you're requiring me to get vaccinated, to me, an employee could just refuse to do it. Now, what I've seen happen is they then say, okay, you may not come into work, and they're suspended without pay. And suspension without pay, or if they said, okay, you have to, in that case, you can only work part-time from home, and then, like you said, your pay is cut, or they somehow severely change your job so that your job is less meaningful, you have fewer responsibilities, you manage fewer people. The job changes in a significant enough way that it's not what you signed up for it. Employment law is a kind of special area of contract law, but you have an employment contract, and you're not doing what you agreed to work there to get paid to do. And so in that case, you can bring what's known as a constructive dismissal claim, and it basically says, you fired me without firing me. You never gave me a notice of this contract is over, in which case they may owe you, they likely do owe you some money, unless they can show you're fired for cause, which it's known as the capital punishment of employment law. If you're fired for cause, it's not supposed to be easy to do. So if they can't show that, then they should be paying you something. And in other words, you don't have to wait around. Like I've talked to many people who are on unpaid leave. It's basically like you just stay home and be not paid anything until you go get yourself vaccinated, right? And you don't have to sit around and wait forever till they invite you back to work, because that could be months or years. You can say, no, I'm suing you. You're going to pay me my notice. Yeah.
Wow. Okay. And does that happen? Does anybody actually win those cases, or is anybody trying to fight for that?
Yes. So, but in employment law, those cases very rarely go to trial. They're almost always settled, right?
Oh,
they're not usually for massive amounts of money. So if you've worked somewhere for a few years, you might be entitled to a few months of notice or pay in lieu of notice. Right. So if you're making, just for easy math, $10,000 a month, and let's say you're entitled to 5 months notice, if your employer tries to deny you that $50,000 payout, it's going to cost you probably more than $50,000 to go all the way through a court hearing until you get to a court decision. But you might file a claim and say, I've been wrongfully dismissed, and then try to work out some kind of settlement. But there are claims like that being made that I'm aware of. But I haven't seen any decisions, and these things tend to be quite slow, right? Any court decisions on that kind of a case. I mentioned before that I've seen labor arbitration decisions, labor adjudicator decisions on whether a workplace policy is reasonable when a union is grieving that policy.
I've heard of not heard of, but there are situations where people are being let go and then their EI's been taken away. What's your take on that?
Is that, just to clarify, is that because it's with cause, like termination with cause? Is what my differentiating factor expectation would be. Because if you're
Yes.
terminated with cause, you don't qualify for EI.
This is an interesting thing here. Is it's because it's the federal government's discretion, it's the federal government's direction to not pay people who are fired for or who have been laid off without pay for that reason. So it's not that you've been fired for cause. You're not actually fired for cause as an authoritative matter unless a court has said so, right? Or
unless a court has said so.
So for the purposes of EI, right? If it's alleged that you're fired for cause, that's something that you can dispute. I think the federal government has essentially given the position that, in its view, if you're laid off or fired because you're not vaccinated, that is for cause. What I'm trying to say is, it's not for the federal employment minister to say that as a matter of Ontario employment law, right? Because this is a provincial matter, that you, in fact, for most employers you would work for in Ontario, that this is in fact dismissal for cause, and that's also true of other employees. So the minister's position that we won't pay EI is not the same thing as saying, in effect, you're all fired for cause. That's not for the Minister of Employment to decide. And I think that decision, I think it can, when it comes to what your employer puts on the paperwork when you're fired, that I believe can be reviewed. I haven't done that myself yet. Help someone kind of challenge their EI status, but my understanding is that it can be done. I think with the announcement from the government that their position is basically we won't pay this out, that's probably going to have to be decided by a legal battle, whether that's legitimate within the minister's discretion to make that kind of an order and to exclude people from a public benefit program, right? This is another interesting area of law. Again, public law or administrative law is what the administrative branch, the bureaucratic branch of government, is huge and is granted a lot of discretion, right? A lot of our law is a statute says the minister has the authority to make regulations, and then the regulation says the minister can make policies, and then the minister makes policies and makes a lot of discretionary decisions. So we've got one minister's office saying, all you people who lost your job for this reason, none of you are going to get this program. Well, that minister didn't create the program. It was created by statute. What is within the minister's discretion to do? That's it's an interesting question. It's probably going to have to get worked out by a court case. Regrettably, probably not soon enough for people to get money now who need it now. But that's what I suspect may happen.
Yeah, well, I guess for me, I'm thinking, most people are thinking like that just seems unnecessary to take away a person's EI for that reason. It almost seems unconstitutional. Is it?
In terms of is it unconstitutional? That's an interesting question. Before I get to that, just my initial thoughts were when you were saying it seems unnecessary. Well, let me agree with that. I think even the look, I've seen opinions from large law firms from months ago, so early in the summer, on whether you could require vaccination, and they seemed pretty skeptical that most workplaces would be legally able to, not as a matter of constitutional law, just a matter of employment law, able to require people to get vaccinated, and that seems to have rapidly shifted. It's amazing how what a judge or adjudicator is going to assume to be reasonable changes quickly as everyone gets hyped up about vaccines being our society's way out of this. So I think the federal government's move before the last election, right, just before the election, they announced all federal public servants, they're going to have to get vaccinated, right? And then they're also going to require vaccinations for airline and other federally regulated industries. And they dropped this, I think, as they needed an election issue. I mean, they were calling this election in the hopes of getting a majority before the new opposition leader was better recognized or what have you. And so they were trying to create election issues, and they thought, Canadians generally seem pretty supportive of strong COVID measures. We know that there's going to be a contingent out there who are against mandatory vaccinations, and in fact would be very upset about it. It'll probably cause some problems internally within the Conservative Party, the main opposition party. They're probably right about that, and so I think it was a political move that unfortunately has kind of, accelerated our this drive into a remarkable commitment on the part of people. I mean, you may have seen that poll about a majority of Canadians wouldn't have friends or family over into their house if they weren't vaccinated. I mean, this is not a healthy society, and it seems like our government is happy to exacerbate those divisions and those fears for political purposes. And I think this decision from the employment minister, I don't think it's really about. I'm sure it may save some money, although if it gets litigated successfully, it's not going to save the government any money. But no, I think it's political, right? They're showing look how committed we are to pushing vaccination and to demonizing the unvaccinated, right? That's been our prime minister's commentary as well, right? On the unvaccinated is like, basically we're in this mess still because of them. I don't think the data really supports that, but that's where we are. So, in terms of a constitutional challenge to it, I think one way, at least as it applies to those who work for the government or who are in an industry where the government says you have to have a vaccine requirement, that's where you can invoke the Constitution. The addition of denying EI may make the case stronger, where you say, and this is there's a CBC article actually that you had shared with me where they're discussing what kind of a charter case could you make. Section 7 of the charter protects the right to life, liberty, and security of the person, right? And that doesn't mean you get to have or keep a certain job. But if the government says, look, you have to get vaccinated, which is a liberty issue. Liberty protects the right to make decisions of fundamental personal importance. Security of the person is an interesting one, because they would say it's actually good for you to get vaccinated, but you can make a certain argument under Section 7. There are arguments you can make about bodily autonomy, even the decision to have a doctor lethally inject you, right? Section 7 was life and liberty and security of the person. All of those were led us to the right to be euthanized, right? So this idea of not receiving a COVID vaccine would be protected by Section 7. But the question is then, what is the penalty for not doing so? And the government would argue you don't get to. Section 7 doesn't give you a right to a particular job. But I think if you could make the argument that, look, losing your job, being robbed of your job, and being robbed of employment insurance benefits is so effectively coercive that the government's policy is coercing you into getting the vaccine in breach of your liberty. And there's other arguments you can make. You can make a Section 2 argument in the Charter, which protects freedom of conscience. If you can show you have a conscientious or religious objection to the vaccine, that's an easier threshold to get over, because it only requires even lesser forms of government pressure, right? You don't get funding for Canada Summer Jobs unless you make this. That is a breach of religious freedom. So that's another angle that could be used here, another argument that could be made. Those would apply to the policy generally. I don't know if there's a strong constitutional argument specifically against the decision to deny employment insurance benefits. I'm not sure that there is, but there are other arguments that can be made, right? I mentioned about what is the scope of the minister's authority to operate this program, right? To set the criteria, to say who does or doesn't get benefits under this program, which was created by statute and not by her.
No, that's good. Thanks for clarifying that. Because again, in another WhatsApp chat, I have the WhatsApp chats are on fire these days, and so somebody sent me the article that I sent you, the one from the CBC called "The Charter of Rights and Freedoms versus Vaccine Mandates and Government Inaction on COVID." And just for the listeners, kind of curious, what was the point that we're kind of taking away and arguing? So in the article, there was a unique point that was made. And it says, there's a common misunderstanding of how the charter works, says Charisma Mathan, a professor of law at the University of Ottawa who specializes in the Constitution. The charter does not apply to everything that happens in Canada. It applies only to governments, their agents, and their laws. This means charter challenges to a vaccine mandate could apply only if that mandate was implemented by the state, and only government employees can bring charter challenges directly against their employees or employers.
Yeah, that's exactly right. She is right on that. So that doesn't mean only government employees can bring a charter challenge at all, but directly against their employers, right? So if I work for, I'm just going to use the example again of a construction company. It's not the government, and my boss says, new workplace safety policy, you all have to be vaccinated. I have no constitutional argument, right? The Constitution just is not relevant here. The Constitution restrains the government, or it's supposed to restrain the government. So I may be able to try to make a human rights argument or an employment law argument that's wrong to require of me. But if the Ontario government comes and says all construction companies must require vaccination of their employees, now it's still again my boss saying, "Hey, where's your proof of vaccination? I've got to fire you if you don't give it to me," right? Now, interestingly, in that case, my employer is justified in firing me. I can't expect my employer to go breaking the law to keep my job, right?
Right, of course.
So the tough thing there is when the government says you employers have to do this, I kind of lose my claim against my employer for payment in lieu of notice. But now there's a constitutional case against the government, right? So it's the government is telling the employer to require this of me, but I kind of jump over the employer and I sue the government, saying you made this rule for construction companies that affected my livelihood, and I'm suing. I'm saying the policy is not valid. It doesn't leave enough room for conscience rights, religious rights, bodily autonomy rights under Section 2 and Section 7 in particular. And I want this policy invalidated, and maybe I want some damages as well. So that's how that would work in a kind of non-government workplace.
So that's within the Constitution that we can make an argument against the state rather than our employer.
Exactly.
Yeah, would then all the claims against any claim against your employer, would that fall under like human rights claims? If you had some sort of claim against your employer? So
there are two potential types of claims first let me narrow it down. So you don't work for the government, you're not in the union, mm-hmm. right? What are your options? Your employer saying get vaccinated or get lost. One is maybe you do have a human rights argument, a human rights claim, but that requires that you're able to show a human rights code protected ground. So the human rights code protects you have an equal right to employment in general, based on without discrimination based on your sex, your age, if you're above 18 and legally working age, and so on, your sexual orientation, it lists religion, disability, and others.
Isn't it results of a genetic test qualify?
The genetic test is specific to the Canada Human Rights Act or the Canadian Human Rights Act.
Okay.
So that was added. There's some argument that it was already covered under ethnicity or disability, depending on the nature of what genetic test was designed to show. But it was added because there was sensitivity around like insurance companies and maybe certain other companies were requiring those tests where certain ethnic groups might have be slightly more prone to developing conditions later in life that would make insurance a greater risk and so on. So that they were adversely affected by that. And so that genetic characteristic, so the federal human rights legislation, you're protected also based on your genetic characteristics. You can see why that might otherwise fall under ethnicity or disability. And then also there's that part about not allowing these genetic tests. And so that was kind of a specific context, I've looked into that. I don't think it's going to be relevant in this when it comes to COVID vaccines. But you might have if you have a medical reason for not getting the vaccine, you could make a disability argument. Even the state of being unvaccinated and your employer thinking, oh, you're more likely to be a carrier of COVID, then there could be an argument about perceived disability, right? That you're more of a risk that way. And then the other obvious one is creed. In the Ontario Human Rights Code, it's referred to as creed, right? It's just religious belief. Do you have a religious belief that prevents you from getting vaccinated? And so if you fall into one of those, medical and religious, and of course employers have been trying to say, and the government, that those are extremely narrow and rare, right? Then you could have a human rights basis for bringing a human rights complaint against your employer and seeking damages that way. Alternatively, if you don't, you say, I have no unique medical reason to not get this vaccine, and I wouldn't say I have a clear religious belief against it. Then you fall back on the kind of regular employment law stuff, right? I got sent home, I got laid off because I wouldn't get vaccinated, even though I would, wear a mask or do a rapid test, or I didn't have to be close to vulnerable people or close to other employees or whatever. It's just not reasonable to deprive someone of their livelihood. That would be your argument. It's a wrongful dismissal, regular employment law kind of stuff.
Okay, so we've been talking about employees, but rarely do we ever think about the employers. And I'm sure, just like there's employees who are for and against, there are probably employers who are not for this, and it's actually hurting their business. Do you deal with any cases where employers are coming to you and they're like, okay, we want to sue the government. We want to keep our doors open. This person took a loan out to start this gym, and they're like, okay, you know what? Most of my family's not vaccinated. They need it for their mental health. I want to open this up for them, but the government won't let me. Do you ever have cases where employers are trying to go against them, the vaccine passport?
Agree or disagree with our views? Give us your 2 cents. You can leave your comments on any of our social media platforms or email us at sixcentsreport@gmail.com.
6 cents makes change. 6 cents makes change. 6 cents makes change.
So I don't have many cases where an employer is suing to get out of that. In Ontario, of course, it's less of an issue than in other provinces.
Really?
Quebec, for example, has imposed the vaccine requirement on churches. In certain provinces, there's kind of an option of, if you ask for proof of vaccination, you get exempt from certain health measures. If you don't ask for proof of vaccination, then extra public health measures apply. In Ontario, where we've seen there's new rules now and stricter rules for nursing homes. But initially, the rollout was, we're going to require employers in different sectors like healthcare and education to have vaccine policies. But the Ontario government kind of it covered itself by saying you have to have a vaccine policy that may allow for an education session about the vaccine. So basically, you require people to take a education session that's likely designed to encourage them to get vaccinated, and require them to be rapid tested, right? But then it also added, you don't have to allow this option. So it's this kind of weaselly way of the Ontario government saying, if you're a healthcare provider, if you're a group home, if you're a college, you have to have a vaccine policy, and your vaccine policy may allow for the alternative of rapid testing, but you don't have to allow the alternative of rapid testing. So now if you bring a constitutional argument against that, the difficulty you face is the government can say, well, yeah, even though lots of people are affected in a way that, they have no other choice but to get the vaccine, that's not our problem. That's your employer deciding to not allow the option of rapid testing. So you'd actually have to challenge the rule that you get rapid tested. And honestly, I don't think that's, maybe someday it will be, but right now I don't think that's a winning case.
Okay, so it's like a legal loophole.
That's right. That's applicable in most circumstances where vaccine policies are required. So even a private school is required to have a vaccine policy. There's that alternative option of get educated about the vaccine and get rapid tested. And that's going to be a hard one to look. Most of our COVID constitutional cases brought all over the country have been lost, regrettably. But that's the circumstances we're in. So, but no, I've had I can say this. I've had employers talk to me who are required to indirectly required to have a vaccine policy. So let's say you're someone who does. I keep going back to this, but in this case, it applies. You do construction, and you want to do a construction project for. I live in Ottawa, the city of Ottawa, and the city of Ottawa has a vaccine policy that says all our contractors, must have vaccine requirements in place. So you're a construction company that maybe a third of your revenue comes from your municipal projects, and you can't just lose a third of your revenue. So what do you do, right? I don't want to require my guys to get vaccinated. I don't believe in that, and I don't think it's necessary, and whatever. So I have spoken to employers there, and basically, I think there's some room for employers to, if they do decide to, for their own economic interest, to adopt a policy that they can then share with, they can show the municipality, look, we have a policy. There's some discretion in terms of how strictly they enforce that, right? So if it's the municipality finds out that it's not enforced, they might still say, well, we're not hiring that company because obviously they don't enforce it. And, maybe you have a risk of a whistleblower in the company saying, oh, this isn't enforced. And they, but in terms of, I mentioned earlier, creed, right? If you've got a religious reason to not get vaccinated, employers have been typically rejecting those requests because they say we don't really get how this is religious, or it's not a clear religious requirement, so we're going to reject your request for accommodation. These more reasonable employers who find themselves stuck in this hard position of wanting to do public projects, they can be quicker to grant those kinds of requests, right? Even if they have a vaccine policy in place. But I still think it's sad that these companies are in a situation where they need to do that, right? Where the municipalities are not just saying our own employees, but even contractors who aren't even working directly with city employees need to have these policies. But yeah, sadly, that's where we're at.
Oh wow, that's profound. Because I think about during the civil rights movement and the bus boycotts, and what's unique about that situation is that the bus companies were private; it wasn't public, and so for bus companies that where it's private and there's people that own them, they need the black dollar. They need black people to ride the bus so that they can meet their bottom line. And when you had the Jim Crow laws and the segregation and the marginalizing of black people, and when black people started doing the bus boycott, it hurt them. Now the white guys who own the bus company and the buses, they're like, well, yeah, I might not like them, but this policy is actually hurting us. And so you had white people who were against those mandates because it was indirectly hurting their business. Because for those who don't remember, but what black people ended up doing is they're like, okay, we're not going to ride your bus anymore. This was after Rosa Parks refused to get up from her seat, right? So then black people in general, they're like, okay, you know what? Forget these guys. We're gonna carpool. We're gonna carpool. We go carpool. We go walk, and that's what started that revolution. So that's why I asked the question. Like now, I'm sure there's people on this side where their businesses are being hurt because of these mandates.
Yeah, no doubt there are. Yeah, and we've seen individual stories of a gym or a restaurant, and frankly, just anecdotally, I've heard of people, where it's the restaurant's policy is basically show me your vaccine passport. I don't have one. I said, show me your vaccine passport, which means, hold your phone down and people, there are definitely people who are, look, it's, we're ready to serve you food. We've got, lots of space. It's just, I know of a couple of gyms where, the attitude is similar, where these are people who, if people are fitness keeners, they're kind of like, well, look, we're trying to exercise and so on, and the government's approach has been to shut us down, or to, they want some people in some contexts, they want their not only their patrons, because they have an economic interest, but I've even found that some people who, I'm thinking of a martial arts club, they want their fellow trainees to be able to go. It's more about the sport that you're so engaged in than it is about your neighbors
and the community
Yeah, and the community, than someone else's different decision on whether to get vaccinated, right? And one of the ironic things too, of course, is I've never seen, I don't know if there's ever been a vaccine that people are less confident in, right? Presumably the people who don't want unvaccinated family members to come over are themselves vaccinated, right? So it's if you're vaccinated, what on earth are you worried about? There's the whole the parliamentary thing, right? The parliamentary debate about, there was something, I think it was less than 10 members of parliament who weren't vaccinated when the session of parliament was supposed to begin, and there was this decision by the process committee that they weren't going to be allowed to sit in parliament. And you just think, if there's 330 MPs who are vaccinated, what and then there's 8 people who are not vaccinated, in what room is it safer, for 8 unvaccinated people to walk in than a room that's full of hundreds of fully vaccinated people? And yet they said, no, this room of 330 vaccinated people cannot abide a few unvaccinated people being spread out amongst us. Like, it's just remarkable. But yeah.
Trying times.
So I'm curious. There's something I wanted to circle back on, and I think this might be a good time, unless Darnell had a follow up on what we've just mentioned. We were talking about human rights cases, and I've heard a couple of times this statement being made, and I don't know how true it is, but I'm curious your take on it. The rhetoric we hear from Trudeau and similar people towards the unvaccinated, would it qualify as hate speech?
That's an interesting question. So under hate speech is a bit of a broad term, and there's a couple of laws that it can fall under. So certain provinces, and this isn't going to be relevant to the Prime Minister's comments, but certain provinces have, in their human rights codes, they actually have discriminatory speech or hate speech provision. So Ontario is not one. So if I just in my own, if in my workplace I say something, that's bigoted or discriminatory, and my employer does nothing about it, you might have a discrimination claim based on a poisoned work environment but that's under like the right to employment without discrimination. There's not kind of a general, I made some bigoted remark on my social media or in a pamphlet that I handed out, and that's a hate speech under provincial law, which will really just get you a financial penalty. So that's the provincial law hate speech, which only exists in a few provinces. British Columbia is one. I'm not sure. I don't remember off the top of my head what the other ones. I think Saskatchewan, but Ontario doesn't have it. And then the other is criminal, right? And criminal is a much higher bar. Criminal hate speech, and criminal hate speech is where you are seen to be the kind of test they use is promoting vilification and detestation of an identifiable group, right? So there's incitement to violence, which is one criminal offense, which is, I say, let's, do violent acts against whatever, this person or this group. But, I guess a step down from that, but still a pretty high criminal threshold, is that I intentionally, promote the view that a certain group of people are worthless and deserve to be treated as such, right? So yeah, it's interesting. There's not going to be a case abroad, but no, in the spirit of even just if you were assessing Trudeau as a statesman and a leader, that example or that analogy to what is it that why do we condemn hate speech, right? This idea that we pick a scapegoat group and direct our hatred towards them, and the fear that there's a direct incitement to violence, but our law goes beyond that to say we don't want the step before incitement to violence, which is directing hatred on a specific group, which the next thing that may lead to is violence. And our prime minister, I don't know if I wouldn't say he expects or wants violence against the unvaccinated, but he's plainly has no issue, and it's very poor statesmanship and leadership with having directing people to fear and perhaps hate the unvaccinated as a group.
Mm-hmm. I thought that was kind of funny when I first heard it, and I thought to myself, I was like, wait a minute, is this guy? It almost sounded like I don't know, it was almost seemed like well, of course he was demonizing, but you're calling people misogynists. For people who haven't seen it, we'll put a link in the show notes, because people are probably like, what is Joel talking about? Yeah. But we'll put
a recent appearance on Quebec TV.
They're often misogynists.
yeah.
How often? I don't know.
Yeah.
A good weaselly politician way to put it, but
he was speaking in French, so it'll be translated. But being called racists, being called misogynists, although extremists for people who disagree, and I think it's sometimes we always attack Trudeau, but I don't even think that's necessarily fair, in the sense that majority of people have supported him, right? There are people.
Depends on how you calculate.
Yeah, how you say. Yeah, well.
He won he won an election. Let's just put it that way.
Yes. Yeah. Okay. Yes. But you kind of, that old saying, you get the leadership you deserve.
Mm-hmm.
Right. And our ethos as a country, even after the whole blackface, brownface incident, he's still our guy, right? So right, he's after all, the SNC Lavalin, all of that, he's still our guy. So as much as we're like, oh, look at this, but I think it's more of a reflection of the state of the country and where we're at as a people, versus like, look at this bad guy. Well, I'm like, well, he has his supporters, just like any other president or prime minister in any kind of country.
Mm-hmm.
Yeah, that's crazy.
It's some rhetoric that's let's call it at least slightly concerning.
Yeah.
Yeah, because I mean, and I think regardless of whether it's hate speech, the rhetoric is clearly divisive. And I know we're getting a little bit off topic.
No, Joel. No. I think I know. I think we're still on topic, because we just finished up with Christmas, and I'm sure everybody who's listening, and me and Joel we have our old chat going, it makes Christmas awkward. it makes Thanksgiving awkward. Like, hey, is you kind of nudge your mom. Hey, mom, is Aunt Janice coming? Like, is she? Oh no, she's not welcomed here, or we're not welcome there, or you got to do a rapid test to come in somebody's house, but there's not enough rapid tests. Well, I'm not using my rapid test, so you got to provide the rapid test. But then, hey man, it's a bag of mix up, right? It's a bag of mix up. Like, as much as we're laughing, but this is the heart of the issue for a lot of us when it comes to birthdays and gatherings. It's just super duper awkward. So, you know, when Trudeau makes these statements, it makes our homes, it divides our homes, which is just stupid.
And to bring it back to the we're talking about the Constitution. This is Trudeau. He likes to, paint his party as the party of the Charter, right? His dad, of course, was the pioneer of the Charter, and of course, it's the Liberals who govern with the true understanding of and in the spirit of the Charter, right? That's kind of their thing. And yet, this kind of language. I mean, obviously, this is a personal medical decision, which the Charter has been big when it comes to those issues, and also an issue of conscience, and arguably, there may be evidence that it's other factors at play as well, like in terms of people's whatever, if it's a religious background or cultural background, in terms of how willing or hesitant they are to get a vaccine. This kind of rhetoric, the Charter is meant to protect minorities, right? We have a tendency to, get into a kind of herd mentality and to condemn those groups that aren't doing what the majority thinks is best and right. And the Charter is meant to say, slow down, majority. The minority has rights too. People who disagree with you have rights. There are rights of conscience and rights of religion and rights to be. The Charter is supposed to protect minorities, and here the Prime Minister is, just saying like all the people in this group
attacking minorities.
Right, exactly. It's really certainly not in the spirit of the Charter. It's demagoguery, and it's I don't know how Pierre would feel.
Well, and I don't know if you guys saw it. There was there was a quote by Trudeau. I'll try to find it and put an article. I know I have an article on the proper context of the quote, but there was a quote that Trudeau was criticizing the use of the Notwithstanding Clause by the provinces because it undermines the Charter.
Sorry, Joel. What do you mean Notwithstanding Clause?
So the Notwithstanding Clause is something that the provinces have as a tool that they can override and say, yeah, notwithstanding that this violates the Constitution, we're still going to do it. And maybe John can give a little more context, but Trudeau Jr. was talking about this and saying his father gave this to the provinces. He didn't really want to. It is a sort of undermining, blah, blah, blah. But what's funny is, so this quote got taken out of context. People were sharing it, saying, look what he's trying to do. And what's intriguing or interesting about it is the reason why the out of context quote went so, let's call it viral, was because it represents what most people think he's actually doing. So the quote again is his classification of what the provinces are doing, but it doesn't. But when you chunk the like taking anything out of context, when you take that quote out of context, it looks like he's saying this is what we're going to do. We don't worry about those people's rights. So, John, maybe you can add a little context to the Notwithstanding Clause and what I'm referring to, if you're knowledgeable on that.
The Notwithstanding Clause, Joel, you put it well. It's that technical term is what it sounds like, notwithstanding. But we're despite the Charter, we're going to do this thing, and there's some discussion about whether the way it's written, it allows a government to pass a law. So it's only a law. It's not for a decision, right? There's lots of things that governments do without passing laws, executive action and decisions and so on. You can't use a Notwithstanding Clause for that, but you can pass a law, and the law itself can invoke the Notwithstanding Clause and say, notwithstanding the Charter, we're going to pass this law, right? And the reason we have that is we were, a parliamentary sovereignty system before 1982, which is to say that ultimately it's Parliament that's going to decide what the law is, not the courts. And there was some fear with, adopting a constitutional Bill of Rights that we'd have the American issue where you have judges making controversial decisions that can't be overturned by the legislature. because it's the when the court says this is what the Constitution means and requires, that's it. Short of court packing schemes or just getting more of your judges with your point of view on the court, there's nothing you can do. And I mean the Civil War and all that. That's interesting, right? That's people might not know the Civil War followed on some controversial Supreme Court rulings about slavery. But anyhow, so to kind of give a check on the courts, it was the provinces who were pushing to say it kind of looks bad on the surface to say, notwithstanding the Constitution, we're going to do what we want. It's a little more nuanced than that. It's we know that judges might say that the charter requires this, right? But we are going to say that notwithstanding that, we're going to enact this. So obviously, it could be subject to abuse. And one of the checks, there's even a kind of internal check on the notwithstanding clause, which is the law that uses the notwithstanding clause automatically expires after 5 years. Right? So I'm trying to think of a hypothetical here.
So I guess I have a scenario that you have. My understanding was, and maybe they didn't use it, but if they had you, so my understanding was with the city of Toronto, Doug Ford basically used, I think, the threat of the notwithstanding clause. I don't think he actually used it, but I think he used the threat of the notwithstanding clause as the means that they cut the number of councillors in half.
Yeah, I believe he used it. So that case, and that actually was, to get the full story, he didn't just use it from the beginning. The Ontario government looked at the Toronto City Council and how councillors are elected and had the size of council and said, let's make this smaller and more efficient. Hopefully things will get done. Elections will work more simply, and things will get done better at the city. We're going to basically redo the districts in Toronto and make them fewer and make them kind of overlap with, I believe the design was to overlap with provincial ridings, but I could be wrong on that. But the point is, they're changing how elections work in Toronto shortly before a municipal election. Okay. Now, a group brought I think actually perhaps the city brought the challenge. I did read it, but it's been a while. But the challenge was the charter guarantees the right to participate in elections, right? And that means provincial and federal elections. And so it doesn't apply to voting for a municipality, for municipal figures. And so they argued that basically this was a violation of freedom of expression, that voters couldn't express themselves in the same way with this new system, and candidates couldn't express themselves adequately because the system had changed on them shortly before an election, and it was so far-fetched. Cities are corporations; they are created by provincial governments. Provincial governments set them up, say what powers they have, and they say how councillors are elected. Okay, they're creatures of the provincial government. And the idea that the Constitution prevents the provincial government from restructuring the city government is absurd, right? But that case succeeded. So you have an activist judge telling the province, you can't restructure Toronto based on freedom of expression, right? Because the voting rights thing clearly didn't apply to the right to vote for municipal government. And so that I think, conservatives looked at that and said, this is ridiculous. You get a liberal judge who agrees with the liberal city and doesn't like the restructuring. So they're just going to abuse the Constitution to prevent Toronto from being restructured. Well, forget it. Now they use the notwithstanding clause to basically say to the judge, we disagree with you. We're doing this anyway. Right. So it's not quite this, this boogeyman of, Ford doesn't care about the Constitution. He's just going to override it. Right. The Ford government had a better and more reasonable interpretation of the Constitution. And yet they still, because the court is the authoritative interpreter, they, the narrative is that, when you use the notwithstanding clause, it doesn't say notwithstanding Judge so-and-so's ruling. It's notwithstanding the charter, as, the implication is as so-and-so interpreted it. But that's not how it's presented by Trudeau, of course.
Mm-hmm. So going back to your example, you were saying after 5 years, it's sort of a sunset clause. So, the reason why I wanted to use the Toronto example was like, well, you're not going to undo this.
No, that's right. And in the Toronto case, part of the argument was that they and part of the reason I think the case succeeded is they said it was kind of short notice, right? So a municipal election is approaching. There's already kind of the pre-election stuff going on and campaigning and preparing your campaigns. I think it might have even been taking effect when the municipal campaign period would begin. And so they said that, threw people off enough that it affects their freedom of expression, which honestly, as a constitutional argument, it's kind of absurd. I think judges sometimes just think this is the result I want and that I think is fair, and they, twist the Constitution to get there. But anyhow, that's what happened there. And so the point being, you say in 5 years, the city has been restructured. It's been functioning. That's not going to be undone. And that argument of you can't impose this on us now, there's not enough time before the next election to campaign effectively. That's not a relevant argument anymore. Right.
So technically, if there was some, let's say the scenario was slightly different, in 5 years, they would have to make the case again to continue let's say this scenario. With regards to the sunset clause, like I'm just saying, like if not, obviously in the Toronto scenario, there's no rehashing that would need to be done in 5 years. But what would normally happen, I guess, is what I'm trying to get at. Would they go before the courts again to debate? Would the province just invoke it again? How would that normally work?
Great question. So the way that works is you have to pass the bill again. Right. So you don't have to go before the court again. Insofar as the law, relies on the notwithstanding clause to be valid, you'd have to reenact it. So it's the notwithstanding clause that expires, or the notwithstanding invocation that expires in 5 years. So someone could then challenge that law as unconstitutional and win. So basically what it does is when you say we're using the notwithstanding clause, you're protecting the law from a constitutional challenge for 5 years. Right?
I see.
And so if you want to continue that kind of immunity from constitutional challenge, you have to bring it to the legislature, and it would be a legislative debate, not a court debate, to say, do we want this constitutional protection for another 5 years? If that fails, or if you just don't do it, then that law might be challenged and struck down as unconstitutional. That's why you kind of give it this I called it immunity, this shield against litigation, constitutional litigation.
So I guess then the question would be, does that, and this is where Trudeau's commentary comes from, does that potentially result in the inability to fight by the people? Like
yes, but temporarily. And so the people have another way. I mean, so I'm trying to think. There's the city of Toronto example, but what would be another example? So
it's only happened a handful of times, right? Like,
yeah, no, that's right. I mean, the language laws in Quebec is the main one, right?
Yeah, where, Bill 21 right now.
Yeah, that's a big one. So Bill 21 is religious symbols, right? If you work for a government entity, you're not supposed to show, wear religious symbols or cover your face, and the idea is it's kind of Quebec's secularism law. The state is secular, and so everyone who works for us has to appear secular, right? Because I guess you can't handle renewing your driver's license and seeing someone with a headscarf or a cross necklace or something, right? Because then it looks like the state is religious. It's kind of in my view anyway, a bit of an there's a legitimate sense in which a state is secular, not to say secularist, which is an ideology, but secular. And I think that's a not the right interpretation of that idea. But anyhow, that was another case in which it was used. So during that 5-year period, you do not have a recourse to the courts. You do not have a, which is true. Before 1982, we wouldn't have had that either, right? The solution would be democratic. So if Quebecers decide, you know what, do we really need to fire the teacher who wears a headscarf? which happened, right? And
Mm-hmm.
people have been obviously expressing support for that teacher. There's a political solution to that, and political debate. You don't have to wait 5 years, right? They could change the law before then, but in 5 years, you're kind of guaranteed a debate. There's going to be another legislative debate. So that's the interesting thing. I mean, obviously, the legislature is a majoritarian institution. In a way, the courts are as well, like appellate courts and the Supreme Court, right? You win a case by convincing a majority of the judges, but they're not subject to elections. So in that sense, they're not majoritarian in the sense that they don't answer to the majority of the populace. So the issue here is if you have a government that uses the Notwithstanding Clause to limit your constitutional freedoms, what recourse do you have? Your recourse is convince the politicians not to pass it next time in 5 years, to change it sooner than 5 years, or that's kind of it. And there's a wonderful quote from a famous jurist. He's actually known as Justice Learned Hand. That's actually his name. And he said that liberty lies in the hearts of men and women. And while it lives there, it needs no constitution to protect it. And when it dies there, no constitution is capable of protecting it. And this, so the idea of a constitutional Bill of Rights may preserve your freedoms for a time, as the population's respect for freedom is dying. But I think that more important than having a Bill of Rights is having a populace that understands the importance of respecting each other's and minorities' liberties. Because when the people don't understand that, they tend to support governments that don't respect it, and those governments also, appoint judges that are also going to be less likely to protect them, right? So it needs to be. We obviously had liberty before we had the Charter in 1982. Some would argue that in certain areas we had more liberty. So having a constitutional Bill of Rights is no guarantee. And so by the same token, using a Notwithstanding Clause isn't necessarily the greatest threat. Although, it definitely could be subject to abuse.
So, like, and I guess Joel and I have echoed this sentiment before that, like, human rights doesn't come from the state, right? It comes from God, in the fact that all human beings are made in the image of God. Not to get super spiritual, but it almost sounds like there's a point where, like, we can't put our hope in the Constitution in regards to our civil liberties as Canadians. That's what it sounds like to me, what you're saying.
Yeah, that's right. I mean, the Charter, like other bills of rights, they're pretty brief statements, and even reasonable limits. Our charter rights are subject to reasonable limits that are consistent with a free and democratic society. Well, what do we understand as a free and democratic society? And if we believe it's, Trudeau used the phrase once, I'm not picking on Trudeau too much, but freedom from fear and freedom from want, right? And well, to have freedom from fear, I need to make all of you get vaccinated. And so it's this kind of, you can have this flipping of a free society on its head, or the Charter. So, you read the Charter, you think, wow, I'm glad we have these freedoms and liberties. But whether people understand the roots and the meanings and how you interpret these freedoms and rights, just having a Bill of Rights, is no guarantee of a lasting free society, right? People have to be committed to that and respect other people's freedoms who disagree with them.
Well, I'd like to say this, John, that this conversation has been helpful, and I'm sure it's been helpful for our listeners because there's a lot of people, this issue's weighing on their minds in regards to, did I do the right thing by walking away from my job? Am I crazy for not getting vaccinated and pushing against vaccine mandates? So you've brought a lot of clarity, and I'm sure you've brought a lot of hope to our listeners. What are some ways they can be in touch with you?
Yeah, email is probably the easiest. It's John at acaciagroup.ca, so JOHN at ACACIA
And I'll put that in the show notes page for those that are looking for it.
Yeah, thanks again, John, for coming on. We really appreciate it.
Thanks so much. My privilege.
But you heard me? Does that make sense?
Madden and Mitchell Media.